Good morning, YouTube. I wanted to hop on here and do a summary video of entitled "What is an Arraignment?" Just give you a little background about myself. For those of you who aren't aware, which is probably all of you, since I've just started this YouTube channel and it's still in its newborn stages. My name is Craig Briggs. I've been in practice of law for 10 years. I'm the owner and operator here at Briggs Law. PLLC.com. That's the website. My firm handles criminal defense as well as vacating, sealing, and restoring firearm rights. And I do contract drafting, wills, trusts, estate planning. Again, I've been in practice roughly 10 years. The vast majority of that experience has been in the area of criminal defense. I had worked for roughly 3 years as a municipal attorney here at a local municipal law firm until recently leaving that employ and starting my business back up. So that's really my passion, is to run my own business. So in that time, I've had roughly 50 or so trials, give or take a few. And in that experience, I've gained quite a bit of knowledge in terms of the criminal litigation process here in Washington State. Again, I'm going to be speaking broadly. I'm not going to be speaking specific to any given case. I'm not providing any specific legal advice to any of you all out there. This is meant to be a educational 10,000-foot overhead view of what to expect in a criminal arraignment, just generally speaking. And so I'm going to be speaking based off of my knowledge gained here in Washington State. But a lot of these principles are going to apply roughly through the other states. I would just encourage you all, if you do have questions, consult an attorney of your choosing in your state to advise you on those issues. Now, an arraignment is your first formal criminal hearing after criminal charges have been filed against you. And in Washington State, what that means is that's going to come either from the officer in the form of a criminal citation, or it's going to come from the prosecutor in a form of a criminal complaint. And I hope you all like my coffee mug today. That's Ron Swanson, my spirit animal. In any event, your criminal charge is going to come one of those routes. States vary on this point. Some states require that prosecutors have to file the criminal charges. Other states, like here in Washington, do allow an officer to fill out a criminal citation. Now, after that criminal citation is filled out, you're going to get notice of a hearing. If it is a criminal citation, you're probably going to get that notice right on the citation itself, which gives you a notice to appear at court date. And if it's a criminal complaint, then you will... My apologies, I have to get caffeinated to get through this day. If it's a criminal complaint, then you should get a notice document sent with that complaint, which should be sent to you well in advance of that hearing. Now, if you do have an opportunity to consult an attorney prior to your arraignment date, that would be great. The reality is the vast majority of people do not do that. Those are the A+++ students that are able to do that. So don't get down on yourself if your arraignment's coming up in the next couple days and you haven't done this. Okay, there will be at least 2 attorneys in the courtroom at your arraignment. One of those attorneys will be for the state or the city or county in which you reside. The other individual will be the constitutionally mandated counsel. That's the Indigent Defense Counsel, or standby, or provisional counsel, as they'll refer to them. He's the defense attorney, or she's the defense attorney that will assist you through your arraignment if you don't have counsel, which is going to be the vast majority of you. Okay, this is not your attorney outside of that arraignment. Okay, that's important to remember that. They're there to make sure that your constitutional rights aren't violated at the arraignment before you've had an opportunity to lawyer up. Okay, so don't panic. All right, you're going to have somebody there that's going to help walk you through it. in any event. Now, there is a wide variance, I would say, between the abilities of those indigent defenders. I myself work as an indigent defender. I take private work as well, but I pride myself on all the work I do. Not just the private work, the indigent defense too, because guess what? That's my reputation. If I do a poor job for my indigent defense clients, guess what? Everybody's going to hear about it. So I want everybody to say good things about me. Now the reality is, not everybody is going to say good things about me. But I want 95% of my clients to say good things about me. And right now, I think for the most part they do. And the reason why is because I care when I put work into something. Whether that's a provisional case, it's an appointed case, or it's a retained case. It doesn't matter to me. It's all work with my name on it. And so you want an attorney like that. And you may get one as an indigent defense attorney. You may not. All right? I would encourage you all to communicate with your attorneys via email because it creates a writing. Okay? This is important. Don't make phone calls, send emails, create writings. If you have a disagreement with the attorney, produce the writing for the court. Okay? This will help you in your attempt to get another attorney if you and this first attorney have a falling out. Now, chances are if you have a retained counsel, you're probably going to run into these problems less. That's the reality of it. Tend to get what you pay for. But at your arraignment, just be aware that there will be standby counsel there for you. Now, you have two kind of broad decisions to make at an arraignment. The first, which really is the lesser of the two options, is pleading guilty. Pleading guilty at an arraignment is a rare circumstance. And it's a rare circumstance for a lot of reasons. The big reasons are there's not a complete picture on the case. There's probably limited discovery at this stage. They don't have all the information. Like for a DUI case, for instance, they don't have the blood lab reports back. They won't have them back for over a year, at least in Washington State. Or there's witnesses that need to be interviewed. All right, the list goes on. The picture isn't complete. You haven't had an opportunity to sit down with an attorney and discuss the case, discuss the potential for trial, how that looks, discuss the potential for resolution, how that looks. You haven't done any of this. And so a resolution at this stage, in most cases, would be foolish. Okay, but there are cases where an individual may want to resolve a case in arraignment, and the kind of rare circumstance of that is where maybe there's an issue preclusion for the prosecutor where they couldn't file if you pled guilty on a more serious offense. So basically the prosecutor screwed it up. They filed it wrong to begin with. And if you resolve it, guess what? They don't get a second bite of the apple. That'd be the one circumstance where maybe a plea at arraignment is a smart decision. Okay, but it's a rare one. Doesn't come up much. Prosecutors tend not to make those mistakes, but when they do, the attorney needs to be paying attention and advising clients adequately in consideration of those facts. So the vast majority of you are going to be taking option 2, which is typically the better option in 99.9% of cases, and that is to plead not guilty. Now, if you plead not guilty, you have 3 options. You have an option to represent yourself as your own attorney. This is called pro se. Okay, if you're pro se, you're held to the same standard as any attorney in court. That includes me, who has had 4 years of undergraduate, 3 years of law school. I prepped for the bar exam for 1 year, passed the bar exam. And so I have all that benefit of that time spent studying the law, and then also 10 years of applying it in practice. And so do you think that's going to be a fair fight between me and you who doesn't have that experience? Probably not. Now, I don't say this to dissuade people from representing themselves. It's just the reality. If you're going to represent yourself, be prepared. Do your homework on the law first. You don't need to be a law student, but you should know your way around the courtroom. You should know what the job of the prosecutor is, the defense attorney, the judge, the bailiff, the court clerk. You should know the process for trial, how it starts, voir dire, what that means. If that is a foreign concept, you probably shouldn't be representing yourself. You should know how to conduct an opening statement, roughly. right? This is your opening argument. It's your first opportunity to persuade the jury. It's very important. You should know how to conduct a direct examination, cross-examination, a closing. You need to know how to draft motions. You need to know how to file jury instructions. So there's a lot to learn. And so if you are going to represent yourself as your own attorney, do your homework. Learn these things. Go in prepared, because you will be questioned by the judge on these points and your level of detail of knowledge. And so I'd encourage you to do homework, learn, be your best resource. Now, if you choose not to represent yourself, which will be the vast majority of you, then you have the option to hire your own attorney, of course, anyone who you like, who you can afford, or if you don't feel like you can hire your own attorney, you can qualify for court-appointed counsel, or at least be evaluated for that purpose to see if you qualify. What I would tell you is that here in Washington State, if you're on any kind of food stamps, any state or federal assistance, you're going to qualify. And that would include temporary assistance for needy families, state health insurance, things of that nature. If you're on Social Security disability, you're probably going to qualify. So apply, because you don't want to go it alone. If you have the benefit of an attorney, you're probably going to get the best result. Unless you're a very, very well prepared, quick learner in the pro se realm. Now, at the point of your arraignment, your case will be called up. You'll have your standby defense counsel there with you. You'll be at the podium or at defense table. There's going to be a microphone there. The judge is going to read the charges, or they may ask if the defense waives a formal reading of the charges. I would say in most instances you could probably waive, because if the defense attorney's done his job, then he's explained those charges to the client in advance of that point. But if not, the judge will read them to you, and then they'll ask you how you plead. In the jurisdiction I work in, I enter the plea for the individual. Obviously, we discuss this first, so I know what I have authority to enter and what I don't have authority to enter. Some jurisdictions will ask the defendant enter their plea. If they do, then that's simply stating into the record your plea, whether it's guilty or not guilty. Again, in 99.9% of cases, it's going to be not guilty. And then the court will give you a new hearing date, or they'll give you a date to come back to apply for court-appointed counsel. After this arraignment, you need to hire an attorney, or you need to contact your court-appointed counsel, give them a little bit of time so they can receive discovery, and then meet with that attorney so that you guys can have a plan before your next pretrial hearing, which comes after the arraignment. The only person that you should be discussing your case with ever is your attorney. Don't discuss your case at arraignment. Everybody at arraignment wants to discuss their case. It's really not the place to discuss your case. Number one, because it's in a public setting in the courtroom. It's not private. And number two, you're not attorney represented yet. You're provisionally represented by standby counsel, but there's going to be limited discussion on your case. And really, the defense attorney should be doing most of the talking at that point. You don't want prosecutors overhearing your statements and then that be introduced into the record. Those are called admissions by party opponent, and they come in over a hearsay exemption or objection. So even if you didn't testify at trial, if the prosecutor overheard you say, yeah, my license was suspended on that date, they could introduce that statement. So you don't want to say anything really about your case at your arraignment. The only person you should be talking to about your case is your attorney. I hope this video offered somebody some value out there, at least in terms of maybe mitigating some of the nerves concerning an arraignment. If you have questions in your specific jurisdiction about your criminal arraignment, I encourage you to contact an attorney of your choosing quickly. Don't wait on it. The sooner you get that contact and that discussion, the better you feel about it. And then move forward from there with an attorney that you can trust. If you like the video, give it a thumbs up, leave a comment, and consider subscribing to the channel. God bless. Have a wonderful day.